Hello, everybody. Your judges have returned and we're about to get our hearing started. My name is Ellen Zwarnstein and I'll be your facilitator. I direct the Michigan Center for Civic Education, and your judges will introduce themselves in just a moment. Then they will ask you to introduce yourselves. They will read the question and then we will begin with the hearing itself. And hopefully you'll see some time cards at the right time in this window. Best wishes for a great hearing.
Hey everyone, welcome to day 3. You made it to day 3 of the national finals, and we're looking forward to a great conversation. My name is Tom Vance. I'm a professor of education at Kansas State University.
I'm Rita McCannon. I'm an attorney in Huntsville, Alabama.
My name is Darcy Kern. I'm a history professor at Southern Connecticut State University.
Would you all introduce yourselves to us?
Hello, good afternoon. My name is Shrika Kantala.
Hi, I'm Manvi Harde.
I'm Michael Chen. Our coach is Brianna Willits, and thank you, judges, for being here today.
Thank you so much. We will use the following questions to kind of frame our discussion this afternoon. Question number 1. I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please, for Pete's sakes, whatever you do, support your position. And finally, what limits, if any, would you place on the practice of judicial review? You may begin whenever you are ready.
In Federalist 51, Madison analyzes the system of checks and balances that divides power between the 3 branches of government. This responded to the Enlightenment philosopher Montesquieu's writing that despotism was the primary threat in government.
Judicial review allows courts to overturn unconstitutional legislative and executive actions. The levels of judicial review include the rational basis, intermediate scrutiny, and strict scrutiny, differing on the importance to the issues they address.
Judicial review limits the unconstitutional expansion of federal powers, checking the legislative and executive branches while preserving federalism. In the 1995 case U.S. v. Lopez, the Supreme Court struck down the Gun-Free Schools Act as it violated the Commerce Clause of Article 6, Section 2. This restricted Congress, thus maintaining states' 10th Amendment rights. In addition, the 11th Amendment established the sovereign immunity of states under judicial review, affirming Justice Iredell's dissent in Chisholm v. Georgia that states could not be sued under federal law.
However, judicial review impacts federalism more by strengthening the federal government. In Obergefell v. Hodges in 2015, same-sex marriage bans were found to violate the 14th Amendment's equal protection and due process clauses. This exemplifies the incorporation doctrine, by which the federal government incorporates the Bill of Rights to state governments. After the court incorporated the Second Amendment in McDonald v. City of Chicago in 2010, only the Third, Fifth, and Seventh Amendments remain unincorporated.
Unlike the other 2 branches, the federal judiciary is appointed and violates popular sovereignty, proving to be counter-majoritarian by overturning majoritarian opinions. In the 1989 case Johnson v. Texas, the Supreme Court held that flag burning was legal under the First Amendment, clearly counter-majoritarian, as 3/4 of the American people, according to Pew Research, opposed flag burning as recently as 2006.
Judicial review reflects the will of the people, since federal judges are appointed by the president under Article 2, Section 2. The framers of the Constitution designed the federal courts to support the nation's democratic republic while protecting individual rights. Since the president is elected by the Electoral College under Article 2, Section 1, and the 12th Amendment, appointed judges reflect the people, as the president is chosen under the trustee theory of representation.
I believe that no limits should be placed on judicial review. Despite its potential shortcomings, judicial review promotes ideas such as equal protection under the 14th Amendment. In addition, the principles of stare decisis, as well as a presumption of constitutionality, until a lack thereof is proven beyond reasonable doubt, ensure that the Supreme Court remains reactionary and cannot act independently.
I disagree, as judicial review should be completely abolished, as courts override the will of the people. In Brutus 15, the Anti-Federalists posit that the appointed Supreme Court would be exalted above all other powers in the government. Thus, judicial review impairs the public's ability to engage with the Constitution. The court is now a political instrument, often undermining democratic institutions on behalf of interest groups, which is evident through the case Citizens United v. FEC.
Thus, certain limits can be placed on judicial review to make it more fair. Courts should only exercise intermediate and strict levels of scrutiny. In Craig v. Bourne, the Supreme Court used intermediate scrutiny to establish that different drinking ages for men and women violated the Equal Protection Clause. Likewise, in the landmark case Cooper v. Aaron, the court used strict scrutiny to uphold the decision of Brown v. Board of Education when the state of Arkansas tried to undermine its ruling, both crucial decisions to ensure equality.
Judicial review allows judges to review legislative and executive actions. While it is not explicitly in the Constitution, judicial review is an important practice that often inspires debates over its constitutionality and effects on federalism.
Thank you. Thank you very much. Excellent prepared remarks. We do have a few questions, however. On the whole, it has judicial interpretation of our Constitution had a positive impact on our federal system or a negative impact on our federal system?
The act of judicial review has had a positive impact on our legislation, as can be seen with the court case of Brown v. Board of Education, in which the court essentially, and at that time, it was against the will of the people, or I guess the sentiments of the people, to make this decision. However, within this court case, the Supreme Court upheld Brown v. Board of Education, therefore expanding the rights of minorities.
So there's an example, and most of your examples in your prepared remarks were the Supreme Court striking down state law, right? And so on the whole, has that been, in other words, increasing the power of the federal government and decreasing the power of state governments? Has that been a good thing overall or a bad thing?
I think generally since we have seen the expansion of the federal government, particularly if we compare to the time of the framers, the federal government today is much larger. And generally, this is a good thing, especially since the ideas such as the equal protection and due process clauses of the 14th Amendment have allowed all American people to be treated equally. However, we can also see certain concerns because this does lead to ideas such as Tocqueville's despotism of the majority. Since the federal government has so much more power, the political parties in power or the groups in power can simply augment their own abilities, and this can make our federal government closer to an aristocracy where only a few people are truly represented.
So the Constitution gives the words of the Constitution, the language of the Constitution, leave a lot of room for justices to interpret the Commerce Clause and Necessary and Proper Clause and equal protection and due process clauses and so forth. So when confronted with a decision and interpreting that vague language of increasing federal power or having the states retain or increase their power, what principles would you as a citizen suggest to the court they use in deciding when to increase state power or increase federal power, national power?
In the process of judicial review, an important factor for justices is their own constitutional interpretation. There are different levels of constitutional interpretation with strict constructionism, original intent, fundamental principles, and the modernist approach. And each constitutional interpretation has its own way of paving the path in their judicial review. I
But-
personally,
but excuse me, but what do you think?
I
What do you think as a citizen should be the principles?
I think as a citizen of the United States of America, the fundamental principle interpretation of the Constitution in judicial review is what we should be using to make our court cases or to be determining the change in American society. Because fundamental principles, you are taking the principal ideas of the Constitution, but you are also using it and shaping it in modern day society to forward society as a whole. And we can see this in the legalization of gay marriage and stuff that would have never happened when the framers first wrote the Constitution. But now we need to use the Constitution, the 14th Amendment, the Equal Protection Clause, but we can use that and we can use our newfound knowledge to progress society overall.
So fundamental principles, any other arguments? Any other principles that you would use or suggest to the court?
Yes, to concur with my teammate, I believe that fundamental principles are important, but above all, we should be using the common good, an essential facet of classical republicanism, to advance judicial review and our society. We see that in early judicial review cases, relatively early ones, such as McCulloch v. Maryland and Gibbons v. Ogden, the Supreme Court struck down certain state restrictions, such as taxing the federal bank or interstate trade, because they were simply inhibiting the development of the states, right, under the Commerce Clause or other provisions of the Constitution. And we see that in order to promote the common good of all of the people in the many states, the Supreme Court has made decisions like this under judicial review. And more recently in New York v. US in the 1980s, the Supreme Court ruled that yes, Congress could regulate low-level radioactive waste disposals in states such as New York and Pennsylvania because it would further the common good for the people in those states.
All right, let me interrupt you just a minute while you're breathing. You said in your first part of your speech that you didn't like judicial review at all and you wanted to do away with it completely. What do you suggest? You said you didn't think you wanted, I specifically wrote do away with it. Were you speaking of judicial review, I believe?
In terms of that argument, we were speaking on behalf of judicial review only being used for important problems in American society with using intermediate and strict scrutiny rather than like the rational basis test, because those are strict scrutiny and intermediate scrutiny have to do with gender discrimination, race discrimination, and the rational basis test doesn't really deal with the oppression of minority groups in American society. So judicial review using the rational basis test there could be an argument that is judicial activism, because there's no necessity of the courts to be dealing with those issues using the rational basis test.
And we see that one prime example of this is in the very commonly used cases, Griswold v. Connecticut and Roe v. Wade, that through their rulings, the Supreme Court essentially created a federal statute allowing people to have their privacy regarding issues such as contraception and abortion. And while privacy is an implied right under the 9th Amendment, we do not believe that the Supreme Court should be able to utilize judicial review to make these decisions.
Additionally, the Supreme Court's main goal and motive should be to return powers back to the people, as can be seen with the original Magna Carta that essentially was established to take away the powers from the king and to allow more rights given to the people. And within the Supreme Court, and also stated within Federalist Paper 78, Hamilton also says that the courts should not be too powerful. They don't have the power of the purse, or the sword, and therefore courts will have to essentially balance their own power and also delegate more powers to the majority or to the country itself.
So if courts don't have the power of the purse or of the military, then why do we have to obey them? Why does the president or a state government have to obey what the Supreme Court says? Or does the state government?
As seen with Gonzalez v. Reich, the Supreme Court case which essentially legalized marijuana. However, we see in many states, Arizona as well, that the state governments have not necessarily followed this law because Congress did not essentially enforce it into the state governments. Therefore, while the Supreme Court makes a lot of very important precedents, and it can ensure that the state governments are following the necessary laws. The state government still does have power because the Supreme Court does not have the power to essentially enforce their decisions.
In addition, as my teammate mentioned, even though on the federal level marijuana is illegal, many states have interposed themselves between the federal government and their people to allow for this. And this is essentially a modern version of nullification, right? The states are nullifying federal law. And even though in the past we've seen things like President Jackson just blatantly ignoring the Supreme Court's ruling regarding the Cherokee Native Americans in Georgia, we don't really have that now, since the presidents respect the checks and balances and the separation of powers that are established by our federal constitution that allow us to have such a successful democratic republic and a country that furthers the success of all Americans.
Anything going on in the states right now that the court needs to strike down? Anything going on that's a violation, as you said, of fundamental rights?
I think that one issue that we see is that on a state level, judicial review can impair rights. So we see that in Carpenter v. U.S., the Supreme Court upheld that the government does need warrants to access digital information, but the state of Arizona, in a 2019 case, the state of Arizona v. William Mixton said that police did not need a warrant. So on a state level, the process of judicial review can actually undermine federalism and people's rights.
Thank you very much. This was a day 3 set of questions, as you can see. The questions are ramped up a little bit, and don't misinterpret when we interrupt. We interrupt for your own benefit, right? So that we can give you maximum time and opportunity to kind of prove what you know. And so I pushed you a little bit on developing not only you're obviously all really well versed in Supreme Court cases and principles and ideas, but that's just, that's a big part of being a knowledgeable citizen. But also another part of it is figuring out where you are as a citizen, right? We're all interpreters of the Constitution, not just the 9 members of the Supreme Court. So I push you on that. You came up with a good one eventually after pushing, which is fundamental rights. That's pretty good, right, Tom? When there's issues of fundamental rights, we can strike those down at the state level. But you might have gone further. There are things, the text of the Constitution, Article 1, Section 8, gives us a laundry list of things that are clearly within so there were things that are national in scope. Things that deal with the political there were other ways to attack that, but overall a very good job.
Really was. I appreciated so much how much, not only how much you know, but how much research and work you've had to do to get to where you know. And I'm glad that Dr. Vance, I'm sorry, said what he said about pressing you, because I didn't mean to interrupt to get you to just take a breath. I really had one more question and I wanted to see where you'd go with it, and I appreciated you answering it. And you Shrika bailed him out. You said it. I heard him say it, but you answered it, which was fine. So y'all were very good. Thank you.
I thoroughly enjoyed this. You guys were so good. And I think if I understood you correctly in your opening where you said judicial review should be abolished, I think you were each taking a different position and arguing, one said I thought you were each taking a different position, but boy, this was so good. And coming up with all the different types of constitutional interpretation, the common good and classical republicanism, and then giving multiple cases about it. I could have listened to you guys talk for another half an hour. This was really, really good. So congratulations.
Thank you, judges.
Thank you, judges.
Thank you so much.
Congratulations, everybody. At this time, students, you may stay here for just a moment, and judges, if you could enter the breakout room.
Thank you.
Woohoo! How did that feel?
Oh God, I've never been questioned like that during Q&A. I was like, do they hate us because they're interrupting us? Oh God.
Okay, so they don't, and they would
Yeah.
not ask you those questions unless they thought that they wanted to hear your answers. So that's a beautiful thing when
I'm
they
glad they
press.
clarified that at the end because I was definitely scared during Q&A.
No, they were very genuine when they said that they
Yeah.
really loved the conversation. So congratulations, everybody.
Thank you.
Wish you the very best. Hi, Miss Willits, and good job. All right, we'll see you hopefully later.
Thank you.
Thank you.
Bye, everyone.